Good afternoon, everyone, and welcome to Semple Fraser's webinar on Are the Cookies Still Set to Crumble? Hopefully you can all hear me and are currently looking at the first slide of the presentation. We welcome questions throughout the presentation, and these can be submitted via the questions panel. Questions will be answered at the end of the presentation, and we'll not attribute them to you unless you're happy for us to do so. Simply put your name or company name at the end of the question. Further questions can obviously also be submitted during the Q&A. We anticipate the presentation itself will take approximately 25 minutes and will then hand over to you. Following today's webinar, we'll send you all a copy of the slides which contain my contact information. Please don't hesitate to contact me should you have any questions you'd like answered offline. My name is Scott Kerr, a partner with Semple Fraser. I'm a partner in the corporate department specialising in intellectual property. Today, though, we're talking about cookies, which talking about them just before lunch is probably not the best time to do it. So if you hear a strange rumbling noise in the background, my apologies for feeling hungry. But of course, I'm not talking today about cookies which we eat, but those which are used on websites. For those not familiar with them, a cookie is a small file downloaded onto a device where the user accesses certain websites. The cookie allows a website to recognize a user's device. This means the user's use of the website can be tailored to their requirements. They can be set up to remember them and make sure the layout is as they wish. It's also a type of file which can be necessary for certain operations in a website, such as ensuring that a basket on a sales checkout totals correctly. But they can also be used to find out much more about the user's habits from using the internet, as while most do, they don't necessarily have to expire or stop working when the individual website is no longer being accessed. Some can continue to operate, store, or gain information stored in the terminal equipment of the user after the particular website has been closed down. It's that function and use of cookies that led, a year ago, to new UK regulations, the Privacy and Electronic Communications EC Directive Amendment Regulations 2011. Doesn't that just trip off the tongue? Those regulations being brought into force on 25th May 2011. In fact, they weren't new regulations at all. They simply amended rules which had been in place since 2003. But the amendment was seen as so far-reaching that when they came into force, the government advised that although the regulations were effective from May 2011, they wouldn't be enforced for a full 12 months, giving those operating websites time to get used to the way in which they would now have to be operated. So if these regulations were simply amending the existing rules rather than bringing in new ones, what is it about them that's so far-reaching? The key provisions of these new regulations state that a person shall not store or gain access to information stored in the terminal equipment of a subscriber or user unless, first, the user has been provided with clear and comprehensive information about the purposes of the storage of or access to that information, and that they have given their consent. The first part of that, the requirement to give clear and comprehensive information, hasn't changed since 2003. It's the second part of the provision, requiring the user to give their consent, that's new. Until now, the regulations required the website operator to give the user the option to opt out of being subject to cookies. The simple change brought in by the amending regulations is to turn this round so that there is an obligation to give consent. In other words, the user has to opt in rather than opt out. And it was that element which the government recognised was such a major shift in the way in which websites operate, and indeed much of e-commerce is conducted, that persuaded them there should be a one-year grace period before the new provisions were enforced. But that grace period expires tomorrow. Are you ready for it? Unfortunately, the actual legislation stating what people must and must not do is restricted to the text in front of you. You must give clear and comprehensive information to users, and they must give their consent. The regulations don't say how you're to achieve that, and no definitive answers will be able to be made until there is a decision by a court. Even then, every case is likely to depend upon its particular circumstances. So what practical steps should website operators be taking? Responsibility for enforcing and policing the new regulations is in the hands of the Information Commissioner's Office, whom I'll refer to going forward as the ICO. It's issued some guidelines on what steps should be taken, suggesting this is approached in 3 stages. First, find out what type of cookies are on your website and how they are used in practice. Secondly, assess how intrusive those cookies are. The regulations may make no distinction between different types of cookie, but it is acknowledged that the purpose of the regulations is to increase the level of protection afforded to the privacy of Internet users. In practice, therefore, the ICO is going to be more concerned over cookies which are considered the most intrusive, perhaps those who create detailed profiles of an individual's browsing activity. So if you're only now getting around to looking at these issues despite the year's grace period, focusing on dealing with the most intrusive cookies on your website is clearly the best approach. Thirdly, decide what solution to obtain consent would be best in your particular circumstances. So the first step is to consider what type of cookies you're using on your website. Remember, the regulations apply to the use of all cookies, but in practice it's the most intrusive which are going to be regarded as the high priority by the ICO. The most common type is a session cookie. This allows a website to link the actions of a user during a browser session. They may be used for a variety of purposes, such as remembering what a user has put in their shopping basket as they browse around a site. They could also be used for security when a user is accessing internet banking, or to facilitate use of webmail. These session cookies expire after a browser session, so would not be stored longer term. For this reason, session cookies may sometimes be considered less privacy intrusive than persistent cookies. Persistent cookies are stored on a user's device in between browser sessions, which allows the preferences or actions of the user across a site, or in some cases across different websites, to be remembered. Persistent cookies may be used for a variety of purposes, including remembering users' preferences and choices when using a site, or to target advertising. First and third-party cookies are another type which you may come across. The distinction here is whether it is the website or domain which is placing the cookie. First-party cookies in basic terms are cookies set up by a website visited by the user, the website displayed in the URL window. Third-party cookies are those which are set by a domain other than the one being visited by the user. If a user visits a website and a separate company sets a cookie through that website, that would be a third-party cookie. Not a type of cookie of itself, but a very important consideration is whether it is a cookie which is strictly necessary for the operation of the website. There is an exemption in the regulations which states that it's not necessary to obtain the consent of the user or subscriber where the cookie is strictly necessary for the provision of an information society service requested by the subscriber or user. The term strictly necessary means that such storage of or access to information is essential rather than reasonably necessary. And it's also expected to be interpreted as being restricted to what is essential to provide the specific service requested by the user, rather than what might be essential for any other uses the service provider might wish to make of the data. The most obvious example would be a cookie used to ensure that when a user of a site has chosen the goods they wish to buy and clicks Add to Basket or Proceed to Checkout, the site remembers what they chose on a previous page. That's a cookie which is strictly necessary to provide the service the user requests, and so the exception would apply and no consent would be required. But it will be a dangerous exemption to rely upon if it is a cookie which simply gives an enhanced benefit or makes the site work better. It is something which is essential for the way in which the site operates. Even though no consent is required for the use of such cookies, it's still important that appropriate information is given about them. There are three aspects to consider here, which are also relevant to the way in which consent is obtained. The first is that the consent must be informed, i.e., the user must know what they are consenting to. We then have to consider whether any form of implied consent will be sufficient, and if not, how actual consent can be obtained. As I explained previously, one of the provisions which has always been in the regulation since 2003 is that the user must be provided with clear and comprehensive information about any cookies which are being used on the website. Again, unfortunately, there is no specific provision in the regulations stating what this information must be. But we can look at the ICO guidelines to get a better idea of what might be required in practice. It's important to remember this aspect hasn't changed. Websites should already have been giving users information about the cookies which are used on the website. It's simply that before, users had to have the option of opting out, whereas now they have to opt in. Information is usually provided in a privacy policy, often accessed through a link at the bottom of a web page. But the guidance from the ICO suggests that going forward, that will not be enough. It may have been sufficient where there was an opt-out, but for people to make an informed consent to opt in, the accepted view is that steps should be taken to ensure that users are aware of the information about the cookies and that it shouldn't be hidden away in some privacy policy which can be difficult to find. Suggestions in the guidance include formatting, changing the size of a link to the information or using a different font so that it's highlighted is one way of increasing the prominence of information about cookies. Positioning can also be important. Moving the link from the footer of the page to somewhere more prominent and likely to catch the eye is also suggested as a way forward. And making the description of the link more explicit, perhaps making reference to cookies rather than simply hiding it away as a privacy policy, might also be taken into account. But once the user accesses the policy, simply stating, "We use cookies," will not be sufficient. That will not be an informed consent. The ICO guidelines recommend setting out the different types of cookies which are used, telling the user how information will be collected, and of course, telling them what it will be used for. But if all that information is on your website anyway, surely simply by using the website, a user should be deemed to consent. The regulations require the user to give their consent. They don't state how that consent is to be given. There's therefore an acknowledgement that browser settings may be one means of obtaining consent if they can be used in a way that allows a subscriber or user to indicate their agreement to cookies being set. But at present, most browser settings are not sophisticated enough for websites to assume that consent has been given to allow the site to set a cookie. Indeed, the Department for Culture, Media and Sport, well, that's what it was called at the time, it may have a new name now, commissioned research into the potential impact of the new regulations, which was carried out in February 2011. Despite the fact that the report acknowledges the survey probably has a much higher proportion of what they term intensive internet users than would be given in a true open survey, even with that bias, the survey showed that many consumers taking part had limited understanding of cookies and how to manage them. Only 13% in the survey indicated that they fully understood how cookies work, and 37% said they didn't know how to manage cookies on their computer. So a defense that you assumed the user had set their browser settings correctly is unlikely to go down well with the courts. So what other forms of implied consent might there be? ICO guidelines indicate the level of consent required for any activity has to take into account the degree of understanding and awareness the person being asked to consent has about what they're agreeing to. So if relying on implied consent, you will have to be able to show that the user has a full understanding of the fact cookies will be set, is clear about what they do, and is giving their agreement. Given the survey carried out in 2011 also suggested that 37% didn't understand how cookies worked and 2% had never heard of them, implied consent may be difficult to establish. But provided there's clear evidence that the user would have known what steps are being taken, click-through consent, or where it's clearly stated that if the user carries on they will be deemed to consent, even if they've not actually ticked a box giving consent, could be relied upon and should be sufficient. But I would also recommend that if you're giving the user the option to tick yes or no, you make it clear equally prominently that if they don't respond to either of the boxes but proceed to the next part of the site, they will be deemed to have said yes. The safest approach, therefore, is to expect users to give actual consent. But again, there's no specific requirement in the regulations as to how this consent must be obtained. So it's very much up to the website owner. Message or header bars are a common method already being adopted. Others use pop-ups, though many regard those as potentially irritating to the user. So will it be possible to rely on consent given as part of a general agreement to the terms of use of the website? The concern here is that the consent has to be specific and informed, and hiding it away in the small print in terms and conditions is unlikely to be regarded as meeting those requirements. And because the regulations don't contain specific provisions setting out how the consent is to be obtained, we also have to think about how long consent is given for. It's clear that because the user has to opt in and give consent, they have also to be given the opportunity to opt out at any time. But does this mean they have to opt in every time they access the website? Or can the website owner rely upon the consent having been given at the time of first use, provided there's a way of the user then opting out? Again, there are no specific rules on this, but a sensible approach would be that if the user has an account or subscribes, consent when they first register should be sufficient. But otherwise, fresh consent is required each time they access the site. And as I said, where the consent is ongoing, the option to opt out must always be available. Also, if there is any change in the cookie's use, this will have to be highlighted. Otherwise, you are falling short of the obligation to provide clear and comprehensive information. That may make some practical difficulties of making sure that a user who has subscribed is made aware of the fact that the cookies have changed. It may therefore be better to obtain consent each time. We also have to think about who the consent should be given by. I've had to consider this for a client who provides a subscription service where the agreement will be entered into with the employer, but many users will be accessing the website. The agreement and specific consent is given by the employer in the licensing agreement. But it would be dangerous for the users to be able to opt out, as if the same settings aren't given for every user, this might affect the client's ability to monitor use of the service and ensure that license terms are being complied with, particularly on the number of users and how they're using the system. Strictly, each user is an individual, and the fact that an employer has consented doesn't mean that that individual has. The practical solution we've taken is to include in the license agreement a warranty and undertaking by the employer, the subscriber, that they have made all users aware that consent has been given by them as subscriber to any relevant cookies on the service, and that as they will be using the service in the course of their employment, accessing through an employment-related address, they are deemed to give the same consent as a subscriber. But while that's the approach which we've taken in that particular case, given the fact that the regulations are so vague, we can't guarantee that it applies everywhere. It's simply one approach which can be taken. To show other approaches which can be followed, I'm going now to try to link live to some other websites and show what has happened there. Apologies if we have some technical problems, but hopefully this will work. You should now be seeing the screen of the Information Commissioner Officer's own website. You'll see here that they have taken the banner approach, with the banner prominently placed across the top of the page. That's certainly one approach which can be taken, but surprisingly in the ICO guidelines themselves, one of the frequently asked questions which they suggest is whether someone taking exactly the same approach would be regarded as compliant. The formal guidance makes it clear they cannot guarantee this would be an acceptable approach to take, as it all depends on the circumstances. So very helpful indeed. The ICO then is taking quite a cautious approach, as you would expect, and making sure there is a clear banner there which is always on the site whenever you log in. But now I'm going to look at a site which may have a more bullish approach. Shortly on your screen you should now see the home page of Amazon UK. Now there's no banner or pop-up here at all, making any reference to cookies. To find the right reference, we have to scroll down to the very bottom of the screen. We're just waiting for that to come up on your screens. Apologies for the slight technical delays, we wait for that to come up. But at the bottom, you will see, in quite small print at the bottom of your screen now, cookies and internet advertising. If we click on that link, what we go to is what I would normally regard as pretty close to a standard privacy policy. It states that Amazon does use cookies and how they use them, but it doesn't actually explain in detail what different types of cookies will be. Now, if you were looking at that objectively, would you say that this is giving the user informed consent? Are the cookies which will be used by Amazon intrusive? The next time you access the site, will products reflecting your most recent searches be highlighted? Will you receive promotional emails suggesting you might want to look at particular products? I wonder if the form of their website will change tomorrow when the regulations become enforceable. It will be interesting to find out. We'll now go back to the slides on the presentation. So what will happen if your website doesn't comply? The regulations can be enforced by the Information Commissioner, not by a user directly. And the Information Commissioner has a range of options available to take formal action where he requires. The main options are an information notice. This requires an organisation to provide the Information Commissioner with specified information within a certain time period. Another approach they may take is to ask for an undertaking. This commits an organisation to a particular course of action in order to improve its compliance. The next stage would be an enforcement notice. This compels an organisation to take the action specified in the notice to bring about compliance with the regulations. This might include a notice served to compel an organisation to start gaining consent for use of cookies. Failure to comply with an enforcement notice can be a criminal offence. The ultimate sanction is a monetary penalty notice. This requires an organisation to pay a monetary penalty of an amount determined by the ICO up to a maximum of £500,000. It's important to recognise, however, that the EU directive upon which the regulations are based stresses that any enforcement of these provisions is to be proportionate. In other words, there shouldn't be a sledgehammer used to crack a nut. This was one of the justifications for allowing the regulations a 12-month bedding-in period before enforcement was actually started. And the ICO have stressed that they will take a practical and proportionate approach to enforcing the regulations. They have to enforce the law, but do have some discretion as to how they exercise their formal enforcement powers. They have indicated, however, that they will wish to look at what businesses have been doing in the 12-month grace period. I will not take the view that we didn't have to do anything until 2012 as being an appropriate defence. Those powers of the ICO can now be enforced, and it will be the way in which they are enforced which allows us to give informed guidance as to what steps will require to be taken in the future to ensure compliance. Until then, we have to rely on our best interpretation of how we expect the ICO to apply the regulations. I hope my presentation today has helped you get a better understanding of that. That concludes my formal presentation, and I'd now like to open it up to questions which any of you listening might have. One question which has been asked is whether the same rules will apply throughout Europe. As I mentioned, the regulations are based on an EU directive. They do therefore have to ensure that the rules are applied in the same way throughout Europe. But because it's a directive rather than a regulation, the directive is left to be implemented by national legislation, with each government imposing its own regulations. The UK regulations therefore only apply in the UK. Each member state of the EU will have adopted its own national regulations, which set out the own standards they will impose. They can't impose anything less than the EU directive, so there will always be the obligation to opt in and give consent to the use of cookies. But it may be that in some member states there is a further obligation always to make an express consent available. That would depend very much on the local legislation. Provided your website is .co.uk or is hosted in the UK, however, it would be the UK regulations which applied, and I don't see any concerns over considering that you have to obtain express consent just because your website can be accessed from outside the UK or is operating there. A second question has come in on the level of fine and asking whether that is always or will always be at the £500,000 level. The £500,000 is a maximum fine which can be imposed by the ICO. It may be helpful to look at this in context. It's the same level of fine which is imposed by the ICO under the Data Protection Act for breach of any data protection rules. Now, the ICO has generally not been too aggressive in imposing fines, but in the last 18 months to 2 years has actually become much more aggressive in the way it's approached these, particularly in the case of data which is lost, personal data which may be lost being left on laptops or is taken in some other way from the secure site or the secure server. The ICO then, in those circumstances, has imposed a number of fines in excess of £100,000, particularly on local councils. It relates to personal data, particularly of those subject to social care. Where that information has been lost or stolen, they've decided that a fine should be imposed for lack of appropriate security measures. Fines, as I said, have been about the £100,000 to £150,000 level. Those were seen as quite shocking at the time, but again, that is the cap is 500,000. I would expect the ICO to take an approach which depends upon the level of business generated through the site and how blatant the restriction is. If we look at the example of Amazon, for example, that is a site which I would expect to be looked at quite closely by the ICO, but it may be that they've already been in discussions informally with the ICO to discuss exactly what policies they should be applying. If it were a site of that level, I would expect the fine, if someone were not complying with the regulations, to be quite high. For smaller businesses and for little infringements, I would expect the ICO to take a much more lenient approach and use one of the other approaches, one of the other sanctions available to it, only going so far as to impose a fine if those are being ignored. Another question has arisen on where the site is operated from, just for some clarity on that. And this is where a site is hosted, in particular outside the EU, so as a hosted site would not be subject to the EU regulations. Where a user from the UK is accessing that site, my view would be that it is not subject to the regulations. The practical difficulty we have is that if a user here accesses the site and complains that they their cookies are being used without their consent, they have the practical difficulty of how they actually enforce it against someone who is operating the site outside. If the site is hosted outside the EU, but the business to which it relates is being conducted in the EU, and the information is being applied in the EU, I would, in those circumstances, consider that the regulations will apply. It's rather difficult to work out the context there, but there will be someone, if it is being hosted in outside the EU, but it is for a website owner in the UK, for example, I would take the view that the UK regulations should be taken as applying. Another question which has been asked is how matters will come to the attention of the ICO, whether the ICO will be policing sites or whether it will be a case of complaints made to the ICO which will trigger matters. The ICO will, I'm sure, in certain cases be looking at what sites are up to for certain large organisations. But it will also be triggered by individual complaints. The difficulty which people have is that while you may take the view your individual users may not actually bother complaining, it could also be a competitor who decides to throw a spanner in the works by putting a formal complaint to the ICO. As a government agency, the ICO, if it did receive a complaint from a third party, would have to take that complaint seriously and have to be seen to be investigating the matter. They are not, however, a large organisation, and it will be interesting to see how where their priorities lie in the way that they will approach individual complaints. I believe that's all the questions which have been raised today, and so I thank you very much for taking part in this webinar. I hope you found it useful, and as I said before, we will be sending you the slides and a recording of the webinar to you. Thank you again, and goodbye.